Welcome to U.S. Immigration Talk, where we take your questions live every 4 p.m. Tuesday, 4 p.m. Pacific time or 7 p.m. Eastern, where we ask your questions, we get your questions about U.S. immigration and give general educational responses about the immigration system and how it happens, not intended as individual legal guidance. We're live on YouTube, LinkedIn, Instagram, and TikTok. We usually get hundreds of questions. We try to speed through and get all of them, so please, especially on TikTok, don't ask the same question 50 times. It makes it hard to follow. If you see you're not getting answered for sure, maybe give it one more try, but don't bombard it. Omar, good to see you. But again, I'm immigration lawyer John Kostravi. We'll spend the next half hour taking your questions and talk about U.S. immigration live. We do it every Tuesday, so we'll be back. And sometimes I'll just pop in on a Sunday or something like that if I'm not super busy. So it's good to follow us on YouTube. It's U.S. Immigration Talk. And if the best way to get your question is to follow us on YouTube and ask there, because it's just a more organized format where information comes. So it's not as easy to answer these questions on TikTok. Quick note, the visa bulletin for June was published. For those that follow the visa bulletin, there's some modest gains in some areas, something to look at. Employment-based EB2, F2B, F1, the F3, these categories, if you're dealing with these huge delays, is something that's meaningful for you. So just give you a heads up on that. And we're getting a lot of interviews. A lot of interviews are happening. Almost every day we're getting notices for our cases, getting adjustment status interviews in the United States. So that's a big deal. It happened pretty fast. I mean, typically there were no interviews the last few years. Now they're doing it, but cases are getting done, so we'll just take it as it is. And the other good news is that the State Department has finally released a website that lists their estimates of when an interview notice will be sent out for immigrant visa cases, green card cases. We've always been in the dark of how long it takes to get an immigrant visa interview at a U.S. embassy abroad. And now they're giving it a timeline. So far seemed pretty good. We had a UK case almost immediately after a documentary qualified got scheduled for an in-person interview in London, for 2 months afterwards. So this is super fast, which is good. People getting their lives done. Potentially going to get a marriage case done in a year. I haven't done that in 10. It's been probably 7, 8, 9, 10 years since a marriage green card to U.S. citizen case is approved in less than a year. And we have one right now. It's just hitting that mark. So it's a really positive thing to see happen. Isa asks, people who receive their work permit, do they always receive a social security number? As part of the work permit application, it depends on what kind of work, but it's basically Form I-765 employment authorization document. There's a question that asks if you want to get a social security number or not, and historically they'll get one too. Now, with the advent of the Trump administration, DOGE and stuff like that, there's some more issues happening with the issuance of the social security number, so you may have to go into the office to get it. Now, when Social Security office and ask for it. So that happens. Now, when you may say work permit, I'm talking about the employment authorization document, EAD, or work permit. You may have other work visa categories like the H-1B or the L themselves, where the visa itself is a work permit. You don't get a separate card for that. In those cases, you will need to go to the Social Security office, show the visa to have the Social Security number issued, because they won't be notified that you got this status if you come in with one of those visa categories. So it's very important you stay on top of it. I've had people come in on O1 visas and not get Social Security number for years until they realize it, and they create a bunch of tax issues for themselves as well. But Isa, thank you so much for the good question. Mina says, applied asylum 9 years ago and permit recently filed for adjustment of status, but the asylum I'm not sure, it's probably say pending. Unfortunately, that's the case. Some of these cases stay pending for a long time. Did my asylum interview today? Leah says, hopefully you did well. Congrats. Hopefully it went well. Nana asks on YouTube, I want to ask if I have to bring DNA results, which was sent to USCIS to my interview, visa type IR2. I want to ask if I have to bring DNA results, which was sent to USCIS to my interview. If they got the DNA results, they have it. And, if you have a copy, why not bring it? If you have like an original copy, why not? John Jones says, applying for adjustment of status through K1. It's a fiance visa. How long a time to receive the green card? The receipt number of the case starts at IOE. The time gets green card, it varies dramatically, John. It's just up to the local office when they get to your case and when they want to adjudicate. It could be 3 months. It could be 2 years. It's all over the place. Okay, join through other videos share. Okay, so and Lilia says, also reason I worked permit a few weeks ago. Okay, so hopefully the interview went well. Our office doesn't handle asylum cases, so I can't really comment too much about that. But it's a messy system. There's a lot of crazy stuff going on in administration. We're hearing word of difficulties some judges are having in the sense that they're being very difficult. And while a lot of judges are leaving, a lot of the immigration judges, especially the ones that are like more, not good ones, let's say, if you will, That's from my perspective. They are leaving the bench. The government's saying, here's a buyout. We'll give you some money. You can leave. So there's going to be less and less officers, judges, and people handling the immigration procedures, embassy, consular officers. So you can expect slowdowns and just more and more difficulties. We're seeing this a lot. A lot of immigration lawyers are in the lockbox system. When you submit your case to USCIS, the immigration department in the U.S., you mail it in, and there's an initial group that gets the documents. And more, right now it's happening where they are just sending the case back saying there's an error, we can't accept it, and they're wrong. And so then you have to send it back and forth with them. It takes months sometimes until it's cleared up. And there was an agency, a group called the USCIS Ombudsman's Office. This was a separate organization that would watch over and try to help correct errors USCIS made. The Trump administration shut them down 2 weeks ago. So we can't even use their help to correct these kind of errors. Pretty bad. Dr. Mike Matt says, is it hard to receive an O1 or EB2 or 3 for dentists? Immigration is not hard or easy per se. It's like if you have the requirements, then you have the requirements. And the hardness is just how annoying and how many mistakes the government wants to make. So if you're a dentist who's won a lot of awards, who makes a lot of money, it's documented, it has a lot of citations, has a lot of articles, it's very so and then EB2 and EB3, that's perm. That's if you get hired for a green card process. Not hard, but it's time consuming. But potentially, if you're an O1 level dentist, you may be able to file for the national interest waiver, NIW EB2C, a lot of letters, initials. But suffice to say, like you just prove your works of national interest, something like that. Nana says the DNA results was sent through email. Should I print it? Send it my review? Yeah, go take whatever you can. If they don't want it, then just throw away the paper. But sure, take anything. All right, feel free to shoot out some questions. Happy to answer them here. Normally we got a gazillion questions coming up now. It's things I'm being throttled somehow on TikTok and on different fields. But hey, what is what it is. Gives more time for more in-depth answers to your questions. So please shoot out your immigration questions about U.S. immigration. Other changes that are happening. We got a question from Jen. A friend of mine had an interview and answered yes, having worked with no documents, and answered all the other questions related to it. His lawyer had on his file that he had not worked without it. So if that person is married to a U.S. citizen, it's not per se a problem. But if they're married to a green card holder, there's a problem. They get denied because you can't have unauthorized employment. Then the next level problem that happens is, what was the employment? For example, if they got a job and they claim to be a U.S. citizen to get that job, that becomes like the worst thing you could do in U.S. immigration. But if they're paid cash as like a waiter somewhere and they're married to a U.S. citizen, it doesn't matter. The key is answering truthfully here, so it doesn't come back later that they didn't tell this information. So when you see what options you have, they need to just sit and talk with a lawyer in depth and see it. There's a lot more to it usually. I can't just, those are options. I got to know more about the situation, what the work was, what the marriage status was, what other questions were asked, what other was commented in the case, all that kind of stuff. Dr. Mike says, thanks. You do E2 investor visas? Yes, we do, Dr. Mike. On my website, I have a detailed breakdown of the whole process. It's a long page. But if you go to jqklaw.com and do our E2 page and go over that and then schedule a private consultation. But thanks for the question, Dr. Mike. ATF says I-751 abuse waiver. Is it difficult to prove? The same kind of situation I was asked. I'm going to ask. It's not difficult or easy. It's like, what is the details? What happened? Was there abuse? Was it extreme or not? And then we just go through the details and what evidence we have, all this kind of stuff. So it's not difficult or easy. It's just something you got to do, and you got to do it well, and that's it. Mina says, I received interview for a pending asylum. While I have a pending adjustment, what should I do? Probably contact the asylum office and ask them if they could reschedule and push back the asylum interview. So you have more time for the adjustment of status to go through. And then once the adjustment of status goes through, you get the green card, notify them that you already have a green card, so you don't need to continue with the asylum case. But definitely try to push it back. Don't miss it, because you'll get a notice to appear in NTA. If they won't reschedule, go there and ask them, hey, don't make a decision. I got an adjustment case pending. But typically, you want to push it back. Well, yes. Can you give more tips on the differences between a fiancé visa and a traveler's visa? So when I go down and see my fiancé, I get the right visa and not get in trouble. A traveler's visa, I think you mean a tourist visa. Essentially, a fiancé visa is a tourist visa to come to the United States to get married, because you're essentially not supposed to to get married. You don't have the right, but you can't apply for a visa to come visit the United States, a tourist visa B2. With the intention to stay and get married or something like that. You could come with the intention to get married, but not to stay. But typically, if you come and get married on a tourist visa, you just stay. And so if your intention, if you have a U.S. citizen fiance, the form DS-1 says he asks if you have a fiance in the United States. If you file the tourist visa application to have a fiance here, most likely they're going to deny you. So might as well just do the fiance visa. It just takes longer time and stuff like that. But Molly, it's I really need to see what's going on in your life, what country you're from, what your history is, what you fill out on the forms to be able to really answer that. So please schedule a consultation time with your fiance. We have a guide on this, Ultimate Marriage Green Card Guide. It's at marriageimmigrationlaw.com. The website, everyone could use it, www.marriageimmigrationlaw.com. And the good thing about the guide is if you're doing a family-based case, an employment-based case, more than half, if not like, especially for family, like 90% for family-based cases is the same info. So it really helps get a better understanding of what the whole situation is. Shiga says, any updates on humanitarian parole? Is waiting to get there overseas is going to affect them? No updates. I could provide on humanitarian parole. Edul says, green card holder can't put in for his spouse. Yeah, it's a F2A petition. It's going to take years right now. Shikila, I saw your question. You keep asking it. Unfortunately, I have to mute you for abusing the system. Let's see. Mute. You don't have to ask your question 50 times. That's just not a good thing. Okay, so let's see. So a green card holder can apply for their spouse. It's called an F2A preference petition. They submit form I-130. It takes 2 to 3 years for that I-130 petition to be approved. And then there's another line right now. So essentially, 4 cases where this person is F2A, they're approving the green cards right now of people who filed the case in January 2022. So it's got a little better. It's like 3 years as opposed to 3.5 years, as opposed to longer than that. But just this line doesn't move consistently. It's not like every month it moves forward necessarily. So it might be that it takes longer than 3 years. But that's the situation right now with the F2A category. It's backed up, but if you got to do it, you got to do it. Now, we had a consultation recently with this person who's really messed up. They did their own case and they consulted with a lawyer, just had a couple of meetings, but they didn't go in depth with the other lawyers they talked with. And then they filed their I-130 petition, spouse of a green card holder. Now, the big problem, and I hope everyone listens, these are kind of people who don't realize that, because it's in the instructions, but it's hard. It's a 50-page instruction on this stuff. It's hard to read it all if you don't do this stuff on a day-to-day basis. But the issue is this, like the person here got married and got his green card based on marriage to a U.S. citizen. So he got married and got his green card there. After like 2 years, he divorced that wife who he got the green card from. And like 6 months, a year later, he got remarried to someone new, or just married someone new, and then applied for the I-130. The regulations say if you got your green card based on marriage and you turn around and get married to someone, get divorced, and then marry someone else and apply for their green card, if that marriage happens within 5 years or before they become a citizen, if you will, then the government's going to assume that it's a fraud, that the first marriage is fraud, unless you have a higher standard, clear and convincing evidence or something like that, that it was a real marriage. So in this case, the guy was about to become a citizen when he contacted me, but he filed this case anyway. It's like, well, if you just waited to get married or filed this case an additional 2 months when you become a citizen, you don't have these issues having to prove this higher standard. So it's like people don't know this. Now we got to go and redo this and withdraw that case, get a new one, and then make sure we can document that the first marriage is real. It gets complicated unnecessarily. If they had just come to me, I could have talked with them and planned it out much better. But that's that. Now it says, if the co-sponsor has a wage-paying job and also a freelancer, how to state this on the Form I-864 occupation section? It lets you do both. In the occupation section, there's a part where it says I'm employed, and they write what their employment is, and then it has another part that says self-employed, and you can write it there. So it allows for both things on the form itself, Form I-864. Ito says, if I put it now, can she get a social and work permit? I don't know, Ito. I don't know exactly what you're putting where. If you I-130 does not give you access to a work permit or social security number, so no, I won't do anything for you. Last question, high approval rate for Form I-539 extension and cost. I-539 is changing status from one status to another. Approval rate doesn't make any sense. First of all, there's a change of status or extension of status to B2. There's like, it depends on what kind of extension you do, an H4, O3 or something like that. And cost really depends on your background, what's going on. We don't talk about costs here. And don't ask about costs, but essentially it depends on what your case needs are and what kind of extension you're doing. Is it a B2 extension? Is it, again, an H4 extension? I don't know, L2 extension. But we got or E2 extension. We got to see what's going on. And please note that I-539 is not the same as like an E2. If you're the primary E2 person, you have to file an I-129 extension, not an I-539. So Dr. Mike, we got to see what's going on with your case first. We can answer your question. So schedule a consultation, please, and we talk more about detail. And Ross says, uncle became a citizen. Does his uncle became a citizen? Does his children become citizens automatically? If they're living in the United States with them and they're under 18 and they're green card holders, yes. So I'm guessing that's not the case in this situation. But it says, I have a question. How long does it take to take family petition cases? How long does it take family petition cases? Well, There are several different types of family petition cases. There are spouses of citizens or green card holders. There's parents of U.S. citizens. There's children of green card holder citizens, either under 21 or over 21, married or unmarried. There's sibling cases. So when you ask this question, there's like 10 different variations. And then it adds a different complexity is which country are they from? Because that is different. The India, Mexico, Philippines, China, there's certain other delays that they have for them. And then once they do an embassy appointment, if from Iran, Russia, and all these kind of countries like that, Pakistan, it's even longer to get an interview. And after the interview, it's administrative processing. So as you see these kind of simple kind of questions, how long does things take? There's like a bunch of different stuff that are variables. And some of this stuff is taking years. So we don't know. Maybe Trump administration changes things tomorrow. And whatever I say right now changes. That's why these timeline questions, luckily we haven't gotten many in the last couple of weeks, are very difficult to answer. So I don't want to give an answer that like it's just going to be wrong, essentially, especially when I don't have any other details. Sibling case from Asia. If you're from the Philippines, they're doing sibling case from 2005. If you're from China, they're doing it from 2008. If you're from India, 2006. So you see, like, it just every question, every answer you give me, I have to ask you 2 or 3 more questions. So best to schedule a private consultation and properly, get the information that you need. Mom Steele says, if a child over the age of 24 files a VAWA as a child and abusive green card holder, are they eligible to receive employment authorization and an SSN? If they are denied, they receive a deportation letter. You don't just get a deportation letter. So you have to go to court and do that. So it's not how it works. Whether they're able to receive employment authorization SSN, if a VAWA bona fide is made, I think they can. I don't have to do the VAWA case in my office, so I don't want to talk about too much, but it's possible. All right, let's see. Ad says, I have my interview for May 21st combo interview, but I just got divorced 2 weeks ago in a good term, so I need to file divorce decree, or should I go to interview with divorce decree? If you have a marriage green card case, your divorce, your case is done. You mean I-751 or a marriage adjustment? So marriage adjustment, you got divorced, that's a problem. You need to contact lawyers. Shouldn't be on the show. You should go contact lawyers in private to help you with your case. Okay, user 67 says, hi, my I-618 was approved, but I work without permission. Will be a problem I go to the interview. So first of all, how long did it take for your 618 to be approved? This is a waiver for someone who entered the U.S. or has unauthorized presence in the United States for extended periods of time. Working with authorization isn't necessarily a problem as long as you didn't use fake documents like a fake passport or claim to be a U.S. citizen to get a job, identity theft and fraud and stuff like that, or false claim of citizenship. So those are where it becomes a problem. So we got to dig in deeper into your history to see what kind of work you did, what you said when you got those jobs, as well as other things about medical history, personal history, crime history, arrests, citations, all that kind of stuff, because it'd be very problematic. If there's issues there, it'll invalidate your I-601A. You have to get a new I-601 then. So it's really important to talk about this stuff with the immigration attorney. You probably use an immigration attorney for your case. So that's something you should talk about it with them. But if you want to schedule a private consultation, please go to our website, jqqlaw.com/contact, and fill in the questionnaire. There is a short one, so we can follow up with some more information about scheduling a consultation. Again, that's jqqlaw.com/consultation. So yeah, that's a big thing. The 601A waivers, these are for people that have periods of unauthorized presence in the United States. They entered with a visa or without a visa and overstayed for 10 years. They can't adjust status. They can't file for a green card inside the United States. So they have to go through the embassy system. But once they leave the U.S., they're going to be banned for 3 to 10 years from being able to apply for a visa again. So to waive that ban, you file this I-601A waiver while you're still in the United States. Once it's approved, you leave and do your consular interview. But the problem is the 601A only covers unlawful presence. If you have other violations, it doesn't cover it. You'll need to go to the interview, get denied, then do a 601, a regular 601, not 601A. And the problem with that is these cases are taking 3-5 years sometimes. Recently, some people are getting done in 6 months, but I have one pending 3 years now, and sometimes it takes 5 years to get a waiver approved. And it's not easy. It's not guaranteed you're going to get a 601A waiver approved because, there's all sorts of issues and complications with it. So, good luck. Congrats on getting your 601A waiver approved, but you just got to be careful on the whole picture of it. And to make sure it's okay and you're clear and all that kind of stuff. And sometimes we have situations where a person, for example, has DACA and they could have got advanced parole. And it's easier to do DACA advanced parole and come back in and then to file for adjustment than to go through the embassy, which has more risks involved in it. So thank you so much for your questions. 667. Please let us know how long it took for your I-601A to be approved. I'm immigration lawyer John Castrovi. If you all want to schedule a private consultation, please email the office. Go to our website, jqqlaw.com/contact. Gold Party says, hi, thanks. If you have been more than 3 months in the state you want to apply for citizenship, can bank statements be enough to show proof of residency or driver's license? ID must always be present. I've never seen them be harsh on this unless the person they literally just moved to the state and they put that in their address history for the N400 application for citizenship naturalization. But if you've been living there 3 months and you listed, I haven't seen that be a problem. But typically, you want to show residency through work or housing, a lease agreement. But again, I haven't seen them be strict on that. If you live there and you have some sort of paper trail that shows you've been there for 3 months, that should probably be enough. But I have to see exactly what your paper trail is and your history to be able to answer that question individually. Go ahead. Mina says, thank you for your time. You're welcome. User 67 says, thanks. You're welcome. Do your 67. Please let us know how long it took to get your 601A approved. I'd be interested in getting that data and sharing it. I mean, it's private. No one's going to know who you are. All right. We only got a few more minutes left. Please shout out your questions about U.S. immigration law, and we'll try to do our best to give a good educated answer about how the situation works, not independent legal advice as always. If you are interested in the marriage green card case or family or fiance, that kind of thing, download our guide, the Ultimate Marriage Green Card Guide. The website is marriageimmigrationlaw.com. That's marriageimmigrationlaw.com. And Raw, thank you for the gift. I appreciate it. Oh, we got some internet issues. That's probably what's going on. Gold Party, thanks for your question. Alex and Lillian Xcar, I think you've been a regular. Thank you for coming on the show. Feel free to shout out your questions. We'll take it from there. Snow, thanks for joining the U.S. Immigration Talk Q&A. Mohammed Lagwa, quick notice for those, especially for Nigerian background. I'm getting a lot of emails recently about the delays there. Yeah, the internet's being bad. But essentially, the Department of State has issued timelines for how long things are taking for immigrant visa cases. Go check out the Department of State website for that. Unfortunately, you'll see it's many years for Nigeria, but at least give you a better understanding, a better way to track it. Oriel says, upcoming I-485 interview as adjustment status green card. Prior misdemeanor arrest, everything has been disclosed. Upon interview, if the officer gives me a hard time regarding the arrest, can I refuse to answer? Question. If you refuse to answer a question, they can deny you. What you need to be able to do is properly answer your question. Hopefully you have an immigration lawyer that's going with you and you have the documents, court record showing that it was dismissed or whatever has happened, and be able to explain the situation. So, I mean, I don't recommend refusing per se. I recommend being prepared. So you really need to go with a lawyer and prepare what your answers are and all that kind of stuff. Myron says, why is USCIS not issuing Social Security with Form I-765 card anymore? How can we get it? USCIS never issued it. It was Social Security Office. I think what happened is with the Department of Government Efficiency, Doge, Elon Musk, because they had this crackdown of Social Security Office, that's around the time when the Social Security Office stopped doing that. I think they want you to go in person to get your ID identity, make sure who you are, something like that. So unfortunately, it requires extra work. We're seeing they don't tell us when this stuff happens. Just all of a sudden clients tell us we're not getting Social Security cards. So I would just go to the office, and they're not letting you do by mail or online or phone call. You got to go in person, apparently, right now. Things could change, but it is what it is. So just go and get it sooner rather than later. Lines always get longer instead of shorter, unfortunately. Okay, so that's another one of these headaches you don't expect is the Social Security Office not issuing. So they updated all the forms for immigration, like I-765, I-485, and another one, N400, that says we'll update the Social Security Office, we'll get you a new card and all that kind of stuff. But in practice, they change all the forms and they undo it. So then they can change the forms back to taking that question off that says we're going to do that. But then it becomes a problem because you might have the old form, you're sending it in, the government rejects it because they say we changed the forms. It's just such a annoying. A lot of it's just super annoying, everything. But hey, that's what we get immigration lawyer for. Let us be annoyed for you. You just deal with your life. I'm sure you got a lot on your plate already. You have to deal with this stuff. Jay Ray, thanks for joining us. Martin as well. I'm immigration lawyer John Castravi, 15 years doing this. Has it been 15 years? I think it's like 15 years. Immigration lawyer and just focusing on this stuff. I love helping couples and small businesses. It's a pleasure. Lillian says, hi, John. I have a marriage green card interview in a month in Greece. It's a normal case. I went 2 times in the U.S., stayed 2 months each time. What are some questions that possibly need consideration? So at your interview, they're going to be asking potentially at the affidavit support to make sure, most of it is going to be paperwork to make sure your paperwork is in order. That's the biggest problem people have, police reports, all that kind of stuff. But the affidavit support, updated financial documents to show your spouse is making the income they said they are, updated tax returns, all that kind of stuff. That's the first thing you got to knock out. And then secondly, it's your personal documents, your passport and stuff like that. If you have 2 month stays, it's not important. That shouldn't be a problem. They're going to go over, are you a terrorist? Are you going to do fraud? Are you going to kill somebody? You're going to ask these questions potentially if the officer feels like it. And third, they're going to ask about your relationship, how you met your spouse, how long you know them, how often you see each other, to make sure their opinion that the marriage is real and stuff like that. So those are the 3 parts for a marriage case. is the relationship real? What's the background of the applicant? Do they have any issues? And the third is the affidavit of support. Is the U.S. petitioning sponsor, the spouse usually, sometimes the fiance, can they, do they make enough money to sponsor as their joint sponsor? And are those documents showing the income requirements updated? So the new ones, the new taxes, new W-2s, new pay stubs. So you want to check all that stuff. So just make sure you do it properly. You have to upload it to SEAC, the website for immigrant visas. So that stuff's updated too. And potentially, depending on how long it took for you to get the interview, you might need updated police certificates, which is kind of hard to get in Greece. I've had difficulties with Greece getting stuff on time. So that's something I'd be mindful of. Or any country you've lived in under certain parameters. Like if you, from the country where you were born, if you lived there more 6 months of the age of 16, you have to get a police certificate. If you lived in other countries over a year, you need a police certificate from them. Or if you had arrests in those countries. Pantea, thank you for joining us. Appreciate it. So that's the consular processing process. It ends up being a very time consuming. It's not necessarily the most complicated when people do it on their own. A lot of times people come to us, and consular processing is when you're getting a green card through the embassy. And they've been going back and forth with the government for over a year, huge delays until they come to us and we fix it in like a week. But it's very difficult for people to ask so much information. They make bad errors on the questions because a lot of times they just want to quickly get it done. So the form DS-260 gets improperly completed, and then that causes issues too. So we got to just work together to get things done properly. That's what we get hired for. Jay says, if I have my green card for 4.5 years, can I still start my citizenship process for 4-1 years? I'm not sure what you mean by 4-1. I think you mean 4.5. If you typically have to wait 5 years or 90 days for the 5-year mark, if you satisfy all the requirements for citizenship. If you've been married and living with this U.S. citizen for the last 2 years and 9 months, if you will, or 90 days before 3 years, then you can do that too. I believe says, why are newer cases being interviewed and approved and waiting 15 months? That's the way the government does it once in a while. They just started doing a last in, first out system. So if your newer case going in, they're going to get you first to just avoid things piling up. But what that causes, like older cases get stuck just like yours. Gold Party follows up. Thanks for your time. If I provide a driver's license, should you have it for at least 3 months before you can apply for N400, or can bank account statements showing that's been in state for already 6 months be enough? Gold Power, as I said, I've never once had an issue about this as long as the person was actually living there. I've never seen an issue. So I have to get into your life. Like, where do you live? Is it like you have a lease agreement or something like that? But essentially, if you want to be extra safe, yeah, it's, get the driver's license, show it, and have bank statements, have life there. Wait till you could, in your opinion, or at least with a strong confidence and evidence that you've been 90 days in that state for the N400 application. But I can see what's going on in your life and get my opinion how like your whole history looks, and it's like, okay, this makes sense, and this makes sense. Because a lot of times, like, you'll move somewhere, you'll get a job, or you start joining a gym or a club or something like that. So we have all these other evidence. We got to dig deep in your life to see what's going on. Again, thank you so much for joining the show. Feel free to shout out a question. We'll do our best to answer it. Actually, only got 1 minute. So if there's 1 or 2 last questions, please let me know. I'm Immigration Lawyer John Casarabi. I help families, investors, people starting small businesses, people with extraordinary ability and whose work is in national interest, get visas and green cards. We love helping out. If you want to contact us, best go to our website contact page, jqqlaw.com/contact. J as in Jack, Q as in Queen, K as in King, law.com/contact. And within 24 hours, if not within an hour or two, I'll respond and let you know how to schedule a consultation if it's the kind of case we do, because we don't do asylum cases. We don't do, I do here and there victims of abuse cases, depending on the nature of the case and the history. But typically, again, we help family-based marriage kind of stuff, people with national interest, NIW or EB-1A, and small businesses who are expanding E2 and L1 visas. That's the niche focus we have. We don't try to do everything. We don't try to be everything to all people. I just want to be really good at the few things that we do, so you can rely on us on that. Thank you, everyone, for joining us today. I'll be back next Tuesday at 4 p.m. Pacific, 7 p.m. Eastern to take your questions about U.S. immigration live. I'm Immigration Lawyer John Casarabi. Please follow us on YouTube, U.S. Immigration Talk, LinkedIn, TikTok, Immigration Lawyer John, and Instagram, JQK Law Firm. Have a good one. God bless. Be safe. Bye-bye.